Started in just a minute here. And yes, we are recording today. Okay, here we go. We'll get started. Welcome to the GRadulting Workshop Series, sponsored by Graduate Student Legal Aid. My name is Debbie McCutsky, and I'm the coordinator of services and programs for Graduate Student Legal Aid. Our focus today is all about employment contracts. And I hope you all find yourselves getting very lucrative job offers. And you may get a contract and you may not understand what it says. And that's okay. That's why we're offering this workshop today. And I just want to reinforce, don't sign it until you understand it. So before we get started with the presentation, I want to tell you just a little bit about Graduate Student Legal Aid in case we missed you at orientation. So what does legal aid do? Well, of course, we offer these workshops throughout the spring and the fall semesters. We have an attorney on our staff who helps students with local legal issues. We've contracted with an immigration attorney who helps students with immigration issues, which can be very complicated. I am a notary public, so I can help you if you need something notarized. We also have advocates on our staff for students who have a Title IX issue or they're charged by the university. So it is important for you to know you paid your student fee, so you've already paid for our services. There is no reason to hesitate to reach out to us. If for some reason we can't help you, we can refer you to someone who can, either on or off campus. So we have a terrific website that outlines who we are and what we do, and I will share that in a bit in the chat. So we have a few rules of engagement. We would like to make this an interactive workshop. So if you have a question about something our speaker is addressing, you could post your question in the Q&A. If we have some follow-up questions, the speaker may ask you to unmute and ask your question with all of us. And if you're not comfortable with that, that's okay. Just continue to post your issue in the Q&A, not in the chat. We're only using the chat so you can communicate with me and I can communicate with you. So let's see. I will email the slide deck and the recording to everyone who registered and attended the workshop. And you can always find our workshop resources on our website. So folks, don't be shy about asking questions. We are all here today to learn together. So I am pleased to introduce our speaker who has generously shared her time with us many times over the past 6 years. You hear that? 6 years. So please join me in welcoming attorney Joyce Smithey. She is the founder and owner of the Smithey Law Group in Annapolis. And attorney Smithey is a highly respected employment and labor law attorney who represents employers and employees throughout Maryland, the District of Columbia, addressing a diverse range of legal matters. She's got more than 22 years of employment law experience and brings a wealth of knowledge to helping clients cost-effectively protect their interests. So I am so happy to see you again today, Joyce. I am going to stop talking and let you take it away.
Great. Thank you, Debbie. It's great to be back. I always get such good questions at this workshop, and I always get some emails afterwards with some fun, complicated problems to deal with employment contracts, so it's a lot of fun. Thanks, everybody, for joining today. I'm Joyce Smithey. I need to update my bio with Debbie because it's been so long. I've been practicing 26 years. When I started Smithey Law Group and started doing this, I had 2 employees. We now have 20, and we're a one-trick pony. All we do is labor and employment law. So this is really my focus in what I do. Let's talk about employment contracts. let's just start with what is an employment contract. Um, you know, we all think of it as a document, and you're going to sign it with your employer. And it's basically going to be a walking, a kind of plan that you walk through for how the employment's going to go. Um, Under the law, oral contracts are just as enforceable as written contracts. We don't think of that. The reason we want them in writing is so that there's not a dispute of what was agreed upon, but an oral agreement is also enforceable. There's also a body of law that says you can imply contracts from employee handbooks. That's going to be governed a lot by different states' laws, and I know you're going to be employed all over the place, but a lot of times when you get your handbook, you're going to see a disclaimer in the beginning that says nothing in here is construed to be a contract. In Maryland, for example, that would be enough to mean you can't sue for breach of the handbook. Um, in other states, that's not the case, right? So just keep in mind that you could be contractually bound from oral statements, from an actual written contract, and sometimes even from a handbook, depending on the state law. What is the covenant of good faith and fair dealing? This is embedded in every single employment contract, and it's to say that the law works from the idea that everyone's going to approach a contract in good faith, and they're going to be fair with each other, right? So if you can show that somebody came in and intentionally had bad faith in how they contracted with you, for example, put terms in there, but there was an amendment provision and they amend immediately or something like that. That could be a breach of the covenant of good faith and fair dealing if they weren't being on the up and up with you when you started your employment. So not every employee has a contract. And in fact, maybe about a third do. Um, so who has contracts and who wants them, right? If you want an employee to not be able to leave, right? Or you want notice because they're going to be so important, right? That you know what, if this employee left, we'd need to have time to plan. Um, Employers are going to offer contracts usually to their higher level employees that they want to say, we need you here for a certain period of time. We're going to need a lot of notice if you leave. But it also limits the employer's flexibility, right? Because it's not a one-way street. It's not like the employer can say, you can't leave for 2 years without them giving something back. If you're going to be expected to have access to confidential information, sometimes that's client lists, client pricing information, sometimes it's trade secrets, or could be like a software code that is proprietary and confidential, that's more likely they're going to want you to be bound to a contract. They're going to want to protect the fact that you're seeing this stuff and make sure your ability to leave with that kind of knowledge protects the company. Non-competes, and we're going to talk about this today. They're still alive and well in many states, not in California. It's a state-governed area of law. But this is a really important thing to look for. I can't tell you how many times I get calls from people who have signed a non-compete at the beginning. They were happy to have the job. They assumed it was all non-negotiable, so they just signed it all. And then they realized that they've signed something saying they can't work anywhere else, for example, within the state, and they have to move to get a new job, and it can really limit them. So you definitely want to look at non-competes. I am handed non-competes all the time that I think are unenforceable. They're overbroad. We're going to talk a little bit about that because that's one you should be paying attention to. Sometimes a highly skilled candidate wants the contract. They want the security. Sometimes they want to know they can't be fired without cause, which is the case. Generally, you don't need cause in all but 2 states. So sometimes employees want it. They want that security. They're moving their family, for example, for a job. They want the security. So again, these are usually for your higher level executives is where you see it. Do they have to offer you a contract? No. I get calls from people saying they're refusing to do a contract with me. Not illegal. They don't have to. And it's usually a very kind of calculated decision as to whether or not they want to be bound to an employee. So no, you are not entitled to a contract. Um, and it doesn't mean you can't ask for one. They may say no, but again, they're going to have a very calculated decision as to whether you are offered one or not. All right, so we're going to talk a lot about what you're going to see, right? I sit across from a lot of people who take a job and they go, well, this is just the legalese gobbledygook. I'm concerned about this clause. It's not a bad idea to know what's in the legally gobbledygook as people come in and tell me, um, because sometimes that's where the fights are. Um, you will have some section on your duties and responsibilities, right? And a lot of people skip over that. But that's where it's going to set out what you need to do. That's what you're giving in exchange for what they're giving you, the salary, maybe a severance provision, benefits, all these things. Um, they usually include a best efforts clause, meaning you're agreeing to give your best effort to this employer. So when you see that, just know that's you're agreeing to do that. So if you breach that, they may be able to claim a breach of the contract. This next one that I have on the slide is very important. Get a copy of all documents that are referenced within the contract. For example, you're going to likely see something saying that you agree to be bound by all policies in the handbook. How can you know that you can comply with that without saying, let me see the handbook? A lot of times you'll see something that says, your benefits will be determined by this benefits policy, and then you don't have it. You want to get a copy of all of it so that you know exactly what you're entitled to, what you're agreeing to give on your side of it. Um, again, most people enter these without anticipating a dispute, but if you have one, the documents are going to be stuff you need to have that fight with your employer if they're coming after you, if they've fired you wrongfully, if they're not honoring your contract. Every time your contract references a document, a stock agreement, right? Some of you are going to go to places where you might get stock options. Get a copy of it because that's going to govern what you can do with your stock options upon a termination or if you leave, right? So usually it's a handful of 6 or 7 documents that are references exhibits. Make sure you have them all, because if you need a lawyer later down the road, they're going to need to see all of that. And if there's a dispute, it's going to be harder to get it then than it is now up front. Compensation. I know everybody kind of goes and reads this part first, and understandably so. It's very important. A lot of times it's easy to read an employment contract and just say, well, I agree with what's in here. But you also want to think about what's not there, right? And you could use this slide presentation as an example of, hey, do I want this spelled out? Do I want it to be said how often I get paid? I certainly don't want to be paid once, like quarterly. That's not going to work for my bills. Some states regulate this. For example, Maryland, you have to be paid twice a month, but it could be biweekly. It could be like on the 1st and the 15th. But if they don't, do you want it specified? And it may be that, they just have a regular payroll, but good to know what that looks like. Um, and so do you want that specified? Ask the question. Bonuses. Um, Sometimes you just see a reference, discretionary bonuses. Ask, are there any policies that apply to the bonuses? Are there any metrics that I have to reach to get to them? Um, you know, you were promised a bonus in the interview and you don't see it in the contract, raise that. Okay, you told me that I'm eligible for bonuses. Where is that in my compensation, right? You may read it that there's a salary there, but if the bonus was promised and it's not in there, you need to make sure it's added in. Profit sharing, something many of you, I know, are in academic focuses where you could end up with stock options, profit sharing. You should see this in your contract. You should get the documents on it that govern how your profit sharing is going to work, how your stock options are going to work. There are going to be separate documents, but you want them addressed in your contract so that should you not get these promised things, you have a contractual mechanism to go get those benefits for yourself. Some people might get promised a company car. We see that a lot for like pharmaceutical sales, things like that. If it's been promised, put it in there. Moving expenses. We've seen more and more of that over the years. Make sure if they've promised it to you that it's ironed out, right? What, is it a set amount and I can go over or under and here's what it is? Or if not, how do I have to submit it? Make sure it's all spelled out if it's something that you're expecting to get. Benefits. A lot of times you'll just see a reference that says you're entitled to the same benefits that everybody else gets at the company. Okay, that's kind of meaningless to you at the beginning of the employment relationship when you don't know. So you're going to want it, again, spelled out. It's very common to see something that says we reserve the right to change these. That's because every year they're probably looking at the health insurance and pricing it out and looking at comparison plans. Employers don't like to be locked into the same health insurance provider in case they can beat costs somewhere else. But you do want to know what you're getting: the health insurance, your vacation and sick leave, all your insurance, everything that's listed here. Get plan documents. Um, all of these types of benefits, not all, but most, your vacation and sick leave probably don't have a plan document, but your insurance will have something called a plan document. And that's what's going to govern the terms of your benefit. And so if you have a dispute about what you're getting for your health insurance, there's going to be a grievance policy that you have to follow. You can't just go to court on that. If you're having a dispute over life insurance or your disability policy, and you want to look at this stuff, right? Because disability policies can run all the way from my firm has the Cadillac of it, right? It's not, can I perform any job? It's, can I perform a trial lawyer job? And, so if I can't do the job that I do right now, mine is triggered. But you want to know, right? Is it going to expect you to go out and get any job, like a retail job, or is it specific to, I can't perform this specific job? You are going to want to look at all of that. And another one is look at payout of vacation upon termination. Almost all states have laws about whether or not you're entitled to that. And many states entitle you to a payout of your vacation time that you've accrued unless they've expressly limited in a contract, right? So you want to know that, right? Because as you're coming to maybe resigning and you think, wow, I've got 5 weeks stored up, that's going to be a nice check. But if your contract that you signed and you forgot about it 5 years ago said, hey, and we reserve the right not to pay it out, that may be legally upheld depending on what state you're in. So take a look at that. And if it's silent on that, it may be something you want to address, so that hey, if I've been this employee who didn't take any vacation time, I want to be able to have a payout at the end of this. Duration is very important. How long are you going to be bound for? You could see 6 months, you can see 2 years, 5-year contracts, and sometimes they're even, sometimes they're even indefinitely and just renew year after year. Take a look at that renewal clause, because you could get trapped into another year without even thinking about it. I meet so many people who say, hey, when can I leave? And I'm like, you just auto renewed last month in a year. Right? So take a look at the renewal. If it's renews year to year, take a look at the notice provision in the renewal. It may be that you have 30 days notice not to renew the contract, or it automatically turns into another year or another 2 years. So take a look at that. And it may not auto renew. It may be that you have to renegotiate this in 2 years. What happens? Have those conversations. Hey, it's a 2-year contract. Am I fired the day after that? Does it renew? What's the process for that? Do I just turn into an at-will employee without a contract and lose the rights that are in here and lose the obligations? Take a look at what happens the day after, especially if you don't see a renewal provision. What's the plan if this contract expires in 2 years? Because you'll want to know that. This one again, I try to cover the things that you may say, what does that mean? You'll usually see a clause saying you don't have a right to enter contracts on behalf of your employer. It's smart for them to do it. They don't want you to be able to bind them to buying thousands of dollars of things. So that's what that means and why they're doing it. You can't contract on behalf of the employer, so you don't have the authority to go enter contracts and stuff if you see that. Exclusive employment. This isn't in all of them. Moonlighting is allowed in some contracts, but when you see that, um, you're not going to be able to work for someone else in the same or similar business. And some of them even extend to being shareholders in a competitor business, and they want you to get rid of those stock portfolios you may have with a competitor. So when you look at that contract, just be careful. You know, as you move on, you're going to start probably saving for retirement. You'll get stock portfolios, and you want to look at what you're agreeing to do there, so that you don't accidentally end up in a breach. At will agreements. Most employees, with the exception of 2 states, Montana, and I'm blanking on the other one, are at will, meaning you can be fired at any time for any reason. You don't need good cause, you don't need notice, and just the same, employees can quit at any time for any reason, right? Giving notice is considered a courtesy, but it's not a legal requirement in at-will jurisdictions, and you're likely to be in an at-will jurisdiction. So if you're going to be in an at-will position, you can expect to get an offer letter. At-will is a powerful doctrine for employers, so you can expect to see them reinforcing it. You are an at-will employee. We can fire you at any time for any reason. We don't need cause. They're going to repeat that in the handbook. They're going to repeat it in the offer letter. That's very standard. So if you're at will, expect to see that over and over in the documents that you're receiving and signing when you start. Termination clauses. This is huge. If you're going to have a fight, it's likely over how this is ending. Can they fire you without any notice at all? Do you want notice? Do you want to negotiate for notice? It may be that they have to give you 30 days notice. If you don't see any notice, you may want to negotiate. Hey, if I'm about to lose my job, I want to know it. 30 days notice. It will also, a lot of contracts have an opportunity to cure, right? Where you want notice and an opportunity to fix whatever the problem is, so that they have to say, hey, you're going to be terminated in 30 days unless you get this report done, or unless, you know, you end this conflict of interest, or whatever it might be. And then you are contractually entitled to have some time to try to fix whatever they claim the problem is. So, you know, they may say, hey, you violated the contract. We think you have stock of a competitor. And then it could trigger an opportunity to cure for you to divest yourself of that conflict and keep your job. So if you want an opportunity to cure, that's something that we negotiate for all the time. And frankly, when I do high-level executive contracts, a lot of them don't have that in there, and we ask for it, right? If you're going to fire my client, tell us why and give us a chance to fix it before you just part ways. Very morbid, especially at the beginning of your career, but there are usually disability or death clauses, right? Contract terminates upon your death. That makes some sense. And disability gets defined in there as unable to perform your job for a certain period of time. You know, good to know what that looks like. Sometimes good to have a lawyer look at it, because sometimes they violate law, right? Because you're entitled to certain amounts of medical leave under statute. And so if they're going to terminate you while you're within your statutory rights, that would be illegal, you know, for the 12 weeks of FMLA that some of you may get. Discontinuance of business. This one actually comes up quite a bit, where people are in a company that is going to be bought out. What happens? Can they terminate me then? Do I get a new contract? You know, that's what you want to look at there. And sometimes I meet a lot of people who are like, we're getting bought out by a company I have zero desire to work for. How can I get out of this? So look for yourself too, right? What's my ability to get out if they're selling to a company that, you know, I don't support? You know, so look at that clause, because it happens, especially in the tech industry. Return of property clause is very standard. It's usually not anything to trip all over. It's just your agreement that you're going to return the company property. And that may be your laptop. So be ready for that, right? If you're going to quit, or they're terminating you, you may have a cell phone you're using, and you need to be ready to turn that back over, you know, download whatever photos and stuff you may have on it. If you're using it for personal uses under their policies, many companies let you do that. So just keep in mind, whatever seems yours because you've been using their cell phones. I have a law firm cell phone that I use all the time, and I'd be lost without it. So just be ready that, if the relationship ends, you're going to have to return all of that. Severance provisions. The higher up you are, the more likely you're going to have this, the more leverage you have, you're going to have this, or the bigger the company, right? Less likely to see in nonprofits, less likely to see in small startups. But this is your chance to say, hey, if you fire me without cause, you should be giving me some severance, as time for me to find another job, get out there, and get going somewhere else and have a salary and benefits continue somewhere else. So if you are someone who can negotiate for severance, now's the time to do it at the beginning. At the end, if the relationship is soured and you're saying, hey, you just fired me, I need some money, it's going to be a much more difficult negotiation. And so, you do often see a provision that says, look, if you're fired without cause, you'll get 2 weeks for every year sometimes, or 1 week for every year, capping at 6 months is a very common calculation we see. So if there's no severance in there, you may not have any severance rights. Certainly, if it references a severance policy, you want to get that because that's what's going to apply to you. Um, and if they have a severance policy, I'd say, hey, can you reference that right in my contract so that in case the policy is part of a handbook that says, hey, this isn't a contract, if it's referenced in your contract, now you have a contractual claim to get to that severance when everything goes south. So take a look for that and see if you're going to be one of those people covered and see if you can negotiate for it. This is as common as it gets. Almost every one of you is going to be asked to sign something that protects trade secrets, confidentiality agreements. I seldom have edits to what companies are asking people to sign these days. They tend to follow the Trade Secrets Act language verbatim to keep them enforceable. So if you have access to any of these kinds of trade secrets, proprietary information, stuff the company's trying to keep confidential, they're going to ask you to sign something. And a lot of times it's also a no-brainer because you're already covered by the Trade Secrets Act. It's not like, oh, if I don't sign this, I can steal their trade secrets. No. You are covered already by laws that say you can't steal it. So this is an additional way that they can come after you if you steal some of their trade secrets on a contractual basis, in addition to violation of the Trade Secrets Act. So evaluations are sometimes mentioned, often not. I can't tell you how often I meet people who are like, I feel like the relationship's starting to go badly, but I have no idea because they don't give me any evaluations. And a lot of people like to have them where they have to give you feedback, right? If this isn't going well, I want you to have to tell me so that I know where I stand and what I need to do. And if it's going well, I want you to tell me that too. And I want you to put it in writing so that it's very clear I'm a good performer. So if it's silent on evaluations, you might want to ask, what's the policy on this? How often can I expect to be evaluated? What's involved with that? Because you want to know. That's going to be the measure of your success there. And it's only fair for you to know what that's going to look like. Work product. This is going to be for people who are creating intellectual property. And I list the examples: books, inventions, software. Know that if you're working on something, anything you do at work becomes theirs. Anything you do, right? So if you were working on something as a student and you start working on it as their employee at work, they can own it. So be very, very careful in what you do at work, what you're doing with your own IP and work, a book that you're writing. A lot of times we'll have a schedule that we attach to an employment agreement saying, hey, my client's been working on this book and they will only work on it on their own time. And you agree that you'll never make a claim that this is your intellectual property. If you've got valuable IP that's your own work product, before you start, be very careful with it. Talk to a lawyer, get that schedule, and make sure they can't make a claim later. because the work for hire doctrine is very strong and the presumptions will be they own it. Um, you're going to see an agreement to cooperate in getting patents. Again, that means that you'll be in breach if you don't cooperate and you're saying, hey, that's mine. You don't own it. They're going to say, well, now you're in breach because you agreed to cooperate in getting patents. Another reason you want to exempt any works that pre-exist that you think have nothing to do with your job. For the first time ever, I actually saw a dispute with a technology company over a children's book. And you think, how, yeah, a no-brainer. But they claimed that they saw her working on it at work, and it ended up in a very large dispute, and it was a successful children's book. So just be very careful with that. Okay, a method for resolving disputes. Not all contracts have this. It's nice to see what that would be, and I personally am a fan of it, right? Some of them. Arbitration, a lot of companies like that. You're going to agree to arbitration instead of law, a court of law. Arbitration is extremely favorable for companies. Companies will hire arbitrators over and over and over. You will hire one once if you're incredibly unlucky. And that means arbitrators who get paid hourly to come sit on disputes get hired mostly by companies. And the odds of winning a case when you're in arbitration go way down if you're in arbitration. So be aware of that. They're going to ask you to sign it. Oftentimes it's non-negotiable. It may be binding arbitration, meaning you have no right to appeal. You get somebody who's not very qualified as an arbitrator. It also keeps it confidential, right? So there can't be any bad press about what they did if it's a harassment case or something like that. So just be very careful. And again, the procedures for selecting an arbitrator, an attorney can advise you on that, but don't let them unilaterally choose it. Most states wouldn't uphold that, but very, very important because that person has a lot of power. It's binding. You can't appeal. They don't have to follow the rules of evidence. And again, the overwhelming percentage of cases go for the companies. Choice of law. What law is going to govern your contract? There's going to be a provision near the end of your contract that may say Delaware law governs, Maryland law. You're going to, even if you're working in some other state, your contract may be governed by a completely different group of state laws. And that's what's going to govern your non-compete that is in there. I can't tell you how many people call and they want to schedule a consult with me. I'm a Maryland employee, and then they send a contract. I'm like, this is covered by another state. You're going to need to know that state's laws. If it's covered by California, for example, non-competes are completely illegal out there. DC as well has very strict non-compete laws. So know what you're looking at, where you're going to have a fight, and what state's going to govern your dispute. Remedies. Generally, you're going to see something that says you agree to an injunction. That's the court's power to come in and order someone not to do something as opposed to money. We're seeing a ton of that with the litigation going right now with the new administration. Injunctions. Hey, we're ordering you not to do these things. It's not for damages. It's an order for certain actions. Usually it'll say you automatically agree to an injunction. You agree to waive bonds. Right. This is really relevant for non-competes. If they think you're competing, they may come after to try to get an order to say you have to lose your current job. And if your contract waived bonds, they may not have to post a bond for the damage they do. And you may be agreeing already that they're harmed by whatever you may do in the future. So take a look at that. That's what that's about. Most people just gloss over it and think that's for the lawyers. It can have some impact if you end up in a non-compete dispute, especially.
Excuse me, Joyce.
Of course.
There's a question in the
Mhm.
Q&A,
Okay.
which reads, how can we be careful of the arbitration clause if we always have to sign them?
Yeah, it's a great question. And it's more in here so you know what it is. I will tell you, I negotiate so many agreements, and that's the one thing they don't back down on. Everything's negotiable but the arbitration. And in the end, a lot of times my clients decide to sign it. And so it's more for your awareness. It is rare, even when you're dealing with multi-million-dollar litigation, for them to back down on it, even when they're getting rid of a major case. Um, It's worth a try. Some of the smaller employers may be open to it. And if not, you just need to know what you've signed and know that in a dispute, you're going to be in an unfriendly forum. And frankly, oftentimes we just recommend people not even have disputes in arbitration, depending on what it is. You can win them. I've won them before, but the odds are something like 96% in favor of them. So you may not be able to negotiate it, and then you have to decide. One of the other problems is everyone's asking for it these days because it's so favorable. So even if you go to another job, they may ask you to sign that as well. So, just keep your eyes open and know what you're getting into. You may not have a choice. And that's very unfortunate. But if you do, get rid of it. Okay. And if there's more questions, keep them coming. I love questions. It means people are listening, so that's great. Notices. This gets screwed up all the time too. You're going to agree in the contract. It's usually maybe 3/4 down into it, how you provide notices to the other side, right? So if I need to give 30 days notice that I'm going to quit, I'm going to give notice, or they need to give me 30 days notice. You're going to agree by contract how that notice has to be provided. And if you don't follow that procedure, it's as if it never happened. So I meet people who come in and say, hey, I've already given my 3-month notice on leaving. That comes up in a month. So I'm good. And I've accepted this job. And I look, and they gave it orally to somebody, or they did an email instead of certified mail. So on the big things of your career, even if you signed it 10 years ago, go back and look. How did I agree to give any notices under the contract? Because and I find ones that still say facsimile, right? And then you're like, okay, I'm gonna have to go to Staples and pay for a fax machine. But if that's what you agreed to, you agreed to it. Or some do say email, but to a specific person. Also, sometimes the employer screws it up and they give you your notice, and people come to me and say, I'm about to be unemployed. I've had 6 months notice and I don't know what to do. And I say, you don't have any notice. They didn't follow the notice provision. You get another 6 months. So that's a place where people kind of can have a gotcha moment if you're not paying attention to how you agreed to give notice. Okay. Representations and warranties. They're going to ask you if their lawyers are any good, whether you have other non-competes, because they don't want to get embroiled in a dispute, right? So if you've got a non-compete, they could get sued if they're interfering with the non-compete. So they're going to ask you to sign something saying, hey, I don't have any other non-competes. I could talk about how to negotiate non-competes for 3 hours in a separate session, but just know many people have them. They're dealing with them all the time. It's not a deal breaker most of the time. It's in fact incredibly rare that I've seen it be a deal breaker. But be upfront about it. What you don't want to do is have lied about it and then your employer gets sued and now they're really angry and you might lose your job when you otherwise wouldn't have, because these are just part of business these days. Entire agreement clause. If you're a lawyer, you're looking at this constantly because I think the lay person doesn't realize how important this is. Entire agreement clause is one of the most important clauses. It's in the legalese at the end that no one reads. And it says, this is the entire agreement. There are no outside promises. There are no outside agreements. There's no handshakes. There's no emails on what we agreed to do. This is so important because people come in and say, but wait a minute, they agreed by email to do this, right? Nope. You have agreed. Only what's in this contract is in the agreement. Emails, everything else don't count. And you can even say, but this should be a separate contract. Nope. This is the entire agreement. So be very careful because people come in and say, well, no, it got amended over the years with all of these emails. No, it didn't. Not if there's an amendment procedure, you get it in the contract and amend the contract. But this entire agreement clause can hold out all kinds of other agreements you've made. So if you're making major agreements that aren't in your contract and you have this clause, you need to be very careful because you will not have any rights on those separate agreements. Independent legal advice is what it sounds like. They ask you to warrant that you've had an opportunity to do that. They just want to protect themselves from you saying, hey, I was under duress and they drafted it and I didn't understand it. So they'll put this clause in there to enforce that, hey, you could have talked to a lawyer. So, there's not going to be a claim for you to get out of this. Severability, very common. Most people their eyes glaze over. It just means if one part of your contract falls because it's illegal, say the non-compete isn't held up, the rest still stands, right? So it's not like, hey, this is going to be taken out by a court because they did this wrong. It means the rest of your contract's still there and you can't get out of the rest of it just because one piece has fallen out.
Excuse me,
Amendments.
Joyce.
Absolutely.
Another question here. The student says, I may have missed this earlier, but should we expect, okay, they're saying maybe I jumped too soon. So why don't you finish what you started there? And Kate, I'm going to ask you to repost the question if you still have that. So go ahead, Joyce.
Okay, sure. Keep them coming. I mentioned this before, amendments. How can the contract be amended? There's usually a provision, and if there's not, you want it to be clear so that you know when you're going to be bound to something new and you can hold them accountable, right? A lot of times it's a written agreement signed by both sides, right? So the email saying, hey, we both agree to modify this way may not be enough. If you've agreed, it has to be a written document signed by both sides. So take a look at that. And when you're doing major changes to the arrangement, hey, we're going to, increase the stock options or whatever. Hey, can we do a quick amendment? We'll both sign it, things like that. Non-competes, huge issue, and ever changing. As you've probably heard in the news, the FTC tried to ban non-competes. That got stayed by a federal judge in Texas. It is up on appeal, but frankly, the Trump administration is likely to abandon that. So non-competes, I think, are here to stay. And these are the ones that say you cannot work for a competitor within 10 miles or within 3 states, right? We're in Maryland, a small state, right? So not uncommon to see, the mid-Atlantic. So, can't work within this geographic area for this amount of time. So that would be a non-compete. Agreements not to solicit business. That is a non-solicitation of clients. You can't call your client and say, hey, I'm leaving the company and I want you to follow me and be my client. That's going to be a solicitation. That would be a violation. Non-solicitation clauses are not under attack the way non-competes are. Those are going to be around for a long time. Non-solicitation of employees. You can't raid a bunch of employees of a company when you leave and say, hey, I'm starting my own. I want you all to follow me. A lot of litigation over that. And again, those are being upheld. Vendors sometimes, although I always like to fight about those because, nobody's going to say you can't use FedEx, for example. So, unless that vendor has limited capacity and they're going to be harmed by it, I always think those are kind of silly. Okay. So courts will review non-competes and strike them down quite frequently, depending on the jurisdiction you're in. Why? Because everybody has a right to earn a livelihood. And if it is so overbroad that you can no longer have a job, the court's going to strike it down. As I mentioned, our economy is based on competition. You can have these hurt the public. And in fact, I've been involved in 2 cases, and one went to trial a couple of years ago on the Eastern Shore of Maryland involving medical practices. And it was an incredibly well-drafted non-compete for a medical practice, but because it was on the Eastern Shore of Maryland, the argument was it hurts the public too much to not have additional medical practices and for them to have to go 20 miles outside of this town, because there just weren't enough medical providers on the Eastern Shore of Maryland. And we ended up in a whole trial just on that issue as to whether or not it harmed the public for this non-compete. So courts will look at these for a lot of different reasons. So how can you tell if yours is going to be enforceable? It has to be something they actually have an interest in, right? So if they're a company that sells hot dogs, they can't forbid you from selling hamburgers. They don't have any legitimate interest. They don't sell those. Obviously, that's a dumb example because you guys are going to be talking about, marketing tech and medical devices, things like that, but gives you the idea. Is it reasonable in scope and duration? Typically, you're going to see most courts start to say no to anything over 2 or 3 years, right? A 5-year non-compete, court's not going to touch it. The court's going to say, no way, like you're not going to have that. The whole United States, for example, I'm aware of only one case upholding that, and it was for a CEO who had contact on behalf of the business in every single state. But for most people, it's going to be, where have you had contacts working for them, and how far did those contacts reach that you developed on their dime? Not harmful to the general public. That's the medical practice, right? And again, I had one with an oncologist, and there was a shortage of oncologists, and it was going to force this oncologist to move to Virginia. Those can be powerful arguments to get rid of these things. Unreasonably burdensome. Again, if you come in and you can't work anymore, the court's not going to uphold that. What are protectable interests? Trade secrets, confidential customer information, right? So if you know, hey, this customer likes to order this type of widgets 5 times a year, and they're going to want these special things, you can't take that to another employer and say, hey, I know all about these people, so we can go pitch them some business because I know their pricing, I know what they order, I know the special things we do for them, I know how they like to, receive it. So all of that can be confidential. Software, a big one. We see that one a lot. Goodwill of the business. If you're out there, and you're associated with the goodwill, there can be arguments that you're diluting that. Unique or extraordinary services doesn't come up very often on that one. These are common, and they're going to be upheld for the most part. So you'll be bound to not soliciting employees. Courts consider the list of employees that you could recruit with these skills confidential information. So you can't say, hey, come work for me. And people get into trouble, for example, because I'm going to show my age, but Facebook, for example, has a lot of contacts from a current company. Then they move, and then they put a post saying, hey, my company's hiring. And then they say, well, wait a minute, you knew that you were posting that to 40 of our employees or something like that. So just be careful if you have a non-solicitation of employees, what you're doing, hey, you should apply at my company, stay out of it, right? They can apply and come, and as long as you don't solicit them, that's fine. They're allowed to go, but you don't want to be involved in that process that brings them on board. Copyright tortious interference concept. Again, tortious interference is an idea that you're interfering with someone else's relationship, right? So if you're a company and you hire someone with a non-compete, that could be a tortious interference and the company gets sued. Or you're stepping in between an employee and their business, and they have a contract and you are helping them violate the contract. Now you can be sued for tortious interference. So a couple different ways they can get you if you are rating their employees. They have to be reasonable. We've talked about this, the geography and time. No hard and fast rules. You just can read lots and lots of cases to see what courts do. Talk to a lawyer. I can tell you off the top of my head what's probably going to be upheld in that regard once I see your industry and what they've put in your contract. I have just examples here so you can kind of see what's, when you get yours, you can pull this out and be like, is this reasonable? Oh, here's some examples of what courts upheld, right? No customers of former employer for 2 years. I would think that's probably going to be upheld. 2 years, again, held enforceable. So just examples here that maybe not as relevant to you right now, but when you get that job, you can go back and look. Unreasonable. Some examples, 5 years. Courts aren't upholding 5 years. Another one for 5 years, a Baltimore city one that was 2 years was invalid because they look at how long it takes somebody to become acquainted with, a competitor, right? So, 2 years off the market is probably enough for somebody else to have found someone else and then maybe decide to come back without it being about, their association with the former employer. Indefinite dates aren't going to be held up. these are just things you can look at again, probably too detailed for your analysis now, but when you look at one, you're going to want to pull this up and um, some states do look, it seems unfair if they fire you. And I love to make this argument all the time in negotiations. So they're so bad, they can't work for you anymore, but they're so good, if they work somewhere else, they'll destroy your business. It makes no sense. But most states say, whether no matter how you're terminated, um, that it's still going to be upheld. Sometimes you see restrictions, you can't have any contact with prospective customers. What does that even mean, right? How can you follow that if you don't know who they are, right? And then you ask and they say, we're not giving you that, that's confidential information. Um, but you need to be able to follow what you're agreeing to doing. Um, so again, you see references to trade secrets here. That's a big part of these non-competes. Unskilled workers whose services are not unique, those are not going to be upheld. And in fact, you're seeing states all over the US starting to say no non-competes for low-wage workers. In Maryland, DC, and Virginia, you can't have non-competes for low-wage workers. You're starting to see regulation of healthcare workers, non-competes, veterinarian non-competes, starting to get regulated, across the U.S. So the more skilled you are and the more unique your services, the more likely they're going to try to lock you down with some of this stuff. If the employer invested a lot in your publicity, put pictures of you on their website, that they're going to have a claim to some of the goodwill that they built for you on their dime. That's a factor as well, if that happens. Unreasonably burdensome to you, right? You own your skills. They'll never own your skills. They only own the confidential relationships that you built. So they're going to be looking, can your skills be used in another business? Can you go get another job? I gave an example here. Somebody had been in the grocery business for 23 years, and then they were saying you can't work in the grocery business anymore. Like, that's the only thing the person does. That's not going to get upheld. Consideration. This is a basic contract theory that for a contract to be binding, each side has to give something up. If not, it's a gift. So you can't just have a gratuitous contract, right? So both sides must give something of value for it to be enforceable, but know that most states say that just continued employment alone is enough to enforce a non-compete. In other words, if they come back and say you're fired unless you sign this, that's enough for them to say, yep, we got something back, you're going to have your job. So we gave you something for that non-compete. The duress defense, I just noted here, is not succeeding. Hey, I signed it because I was going to lose my job. Courts are not buying that and they're striking that down. So if you're going to sign it thinking I'll allege duress because I was going to lose my job, you're not going to win that argument. Blue penciling, again, just something to be aware of, that most courts have a right to come in and change a non-compete to make an unreasonable one reasonable. So don't just think, I'm going to negotiate 10 years because I know a court will strike it down and then I'll end up with no non-compete. A court could come in and change that to 2 years. So don't think just because you have an unreasonable non-compete that you're going to get out with none at all. The court could narrow it down using their blue pencil powers. What happens if you breach? Do you have to pay back the money or relocation costs? Pay attention to that, right? Because you're not thinking about these things at the beginning. Sometimes people get a bonus, and if you quit within the first 2 years, you have to pay some of the prorated bonus back. Know what you're getting into there, because if you take $100,000 bonus and you spend it in the first month and you leave in 2 years, if you don't pay that back, you just made it so that you cannot go anywhere else for those 2 years, because you spent the money and you don't want to have to pay back that sum or your relocation costs, and you can end up trapped in a job that's making you miserable if you've agreed to pay these things back in a certain period of time. So watch out for that. Keep a signed copy of your contract. I would tell you more than half of the people who come to me on a contract breach issue don't have a signed copy. So we don't know, is this the final? Was this a draft? Were there negotiations? Is there a signed copy at all? keep one so that if there's a dispute, your lawyer doesn't have to spend 4 or 5 hours on your dime trying to figure out what is the real agreement here, right? Were there red lines? Did this non-compete go through as is? I don't even know what it is. Get the signed copy. I have a lot of people that come to me with 4 different drafts and they don't know which one got signed. So we don't know what their non-compete is. Get your signed copy from the beginning and keep it. When to get a lawyer? I always think, it's good to just spend a small amount sometimes to just meet with a lawyer for an hour to really understand what you're getting into, because it may be that 99% of the time there's no dispute and it didn't matter, but in the 1% of the time it does. And it may be larger than that, how many employees are having disputes with their employers now. Certainly we see it constantly. We get hundreds of calls to my office. If you end up in a dispute, they are expensive. They can affect your livelihood. They can affect whether will have to move in order to support your family. Certainly if you're in a dispute, you need a lawyer, but I think it's wise to just get somebody from the beginning to help you negotiate, because if you end up in that percentage that are going to have a fight with your employer, they can be career ending. They can be financially devastating to you. If somebody's coming after you for a non-compete, um, you know, that's not something that a lawyer can take a third on contingency. You're going to have to pay hourly for that. And if they're coming after you with a temporary restraining order to lose your job, everything's on the line. So better to be wise and pay a little bit of money up front. Okay, I've ended with 2 minutes before we're supposed to be done for questions. So hopefully that's paced pretty well. I know you might have asked the questions as we went along, but happy to answer any of them.
Right. You're welcome to post a question.
Yep. And I have my contact info up here too. I always get really fun emails from you guys every year. Hey, I heard of this or I heard of that. And, feel free to write it down if there's anything you think of later, or, hey, I heard your speech and I need somebody to look at it.
Right.
We're a large employment firm, so feel free to give me a call.
Yeah. Well, Attorney Smithey, that was, you are always so thorough with your presentations, and you do a great job of covering what we expect to see in a contract and alerting us to what we might not be familiar with or what's not in the contract. So catch your breath and just feel good about the past 60 minutes, because this was just invaluable information. And while I know we didn't have many students join us synchronously, I know that a lot of students will be watching this as we post the recording as well as the slides. So can't thank you enough for coming back again and sharing your experience and your information. So thank you.
You're very welcome. Thanks for inviting me back.
Let's see. We do have a question. What's the latest we can ask questions to graduate student aid about our legal contracts or other things if we are graduating? The date of graduation? That's a good question. Usually we'll go about a month after graduation, but if something is brewing, come to us sooner than later. All right. All right. I don't see any more questions. So thank you all for being together with us. It's important that we connect and that we all prepare ourselves for life today as well as life after graduation. So please remember to complete the post-workshop survey. I will send that to you in an email tomorrow, along with all these other resources. So have a great week. Enjoy the snow. And as always, let us know how legal aid can help you. Thank you.
Thank you.
Thank you so much.